Hi, I'm Sebastian Ryland with Streamline Forensics, and today I want to talk to you if you're a therapist who has a therapy client who's involved with the court and they may want your records. So a lot of therapists in this situation want to know, what do I do? So obviously we got to start with some disclaimers here. Now the first is that jurisdictions vary. So this advice may not apply to everywhere equally. And I'm speaking to the lowest common denominator in terms of possible experiences. And so I can't possibly cover like every circumstance. And then lastly, I'm not a lawyer. I'm not a malpractice specialist. If you have specific questions, please go there. I have had a foot in clinical and forensic worlds for a while. And as I've gotten more of a forensic specialty, I've had a lot of consultation over the years with therapists who are panicking with their clients who have gotten involved in the legal system, or they get a new client that they know is involved in the legal system, and so there's likely going to be some increased scrutiny or some records requests, or they've just gotten their first records request. Some of the most common reactions that I see are a lot of fear, a lot of apprehension. There's a fear of the unknown that totally makes sense. Court is this big, scary thing. If you haven't been a part of it, it makes a lot of sense that would be the reaction. And I think maybe more than that, treatment can be this very private bubble. And so having the actual or possible reality that somebody might pierce that bubble of secrecy is kind of like having your diary read. It's uncomfortable, and that makes sense too. And then another reaction that I commonly see is that people are afraid. They're afraid that their notification or their informed consent procedures don't or didn't maybe appropriately or adequately cover this contingency. Maybe they didn't even know that this was a possibility, and they're learning it alongside the client. And so these are all really valid reactions, and there's a reason that I'm making this video. So I want to start by talking about options versus obligations. And really what that breaks down to is the difference between a court order and a subpoena. So if you have a court order, we're talking obligations. And if you have a subpoena, we're talking options. So hopefully you have some sense from your client about their legal situation. Like if they initiated the proceedings, if they've been dragged into the proceedings, what their position is, so that you have some framework to make a decision about some of this. But most of the time, the kind of take-home message here is that taking more time to figure out some of those variables is going to hurt your client more than help them. So let's start if there's a court order, okay? If there's a court order to release records, then you need to release the records. You don't need a release of information. A court order overrides HIPAA. The court order is the prevailing legal authority that HIPAA references as like an exception. So don't delay responding to the court order, pursuing an unnecessary release. You can certainly get a release if it would make you feel better, if you can do it quickly and efficiently, or use it as a platform to talk to your client about this request. By all means, it's not going to hurt anything to have a release, but do it quickly. And then you may have other HIPAA obligations in terms of recording or disclosing a compelled release like this. So you're going to want to look into that too. Now you should know that the vast majority of legal proceedings, including with forensic psychologists, are working outside the umbrella of HIPAA. And so they're using things like their jurisdictions, data practices acts, court orders, or the other legislation that HIPAA defers to. So basically the take-home point here is don't just say HIPAA and no. Now alternatively, if you have a subpoena, that is usually signed by an attorney. And that's different than a court order. You can object to a subpoena. You're still going to need to respond. But you can object. You can state why you're uncomfortable with that, whatever the reason is. And then you're going to let the parties go to court and argue it out so that the judge can make a decision about whether to issue an order to you to release those records. They may call you in there to explain your concerns or defend your concerns. And ultimately, you should know that the judge can override you. Typically with a subpoena too, you would need a release under those circumstances. Most attorneys will include that with the subpoena, assuming that they're representing your client. If they are the opposing party and they're just trying to get your records, it's acceptable to say that you need an ROI in place in order to comply. Okay, so let's jump back to what happens if there's a valid court order and somebody wants your records, okay? So this is gonna come back down to a really common question, which is, what does it mean to assert privilege? So that is where you can tell the court that you'd like to argue that withholding some or all of the requested records is valid for some reason. There's a good reason to do that. So you still generate the records, you prepare them as if you would be providing them in case the court orders that you supply them. And then you're going to bring them to wherever you're going to be arguing. You should be ready with a coherent rationale that is about the client and not about you. So it shouldn't be something vague like I don't trust so-and-so or I don't understand, why you need them. Those are not valid reasons. And ultimately, again, you need to know that the court can override you and order you to do it anyway. So a lawyer is in a much better position than I am to tell you when and why. So ultimately, if you think that you have records that releasing could harm your client, get a legal consultation. But unless you work in a very specialized area, like with kids who have just been removed for abuse or something like that, asserting privilege is going to be the exception and not the norm. So there may be additional considerations, especially if you do child and family work, things like safe harbor agreements or state laws that can vary around consent and disclosure depending on age and presenting issue. And I can't get into all the contingencies there, but those are just some things for you to keep in mind. The bottom line here is that if it's your client who put their mental health at issue in some way, so let's say they're claiming an emotional injury or something like that, or they're trying to show the court that to prove to the court that they're healthy and treatment compliant, case law has established that they have no claim to privilege. And it's the client, not the therapist, that holds the privilege. So in most cases, you're going to release because the court ordered you to release. So, okay, let's assume you have a valid court order and someone's requesting your records and you're not going to assert privilege or decline this outright. So the most common response I get from therapists when I send them a court order and say I need these records as part of this evaluation, the most common response by far that I get is an offer to provide a summary. And I really do get it. I was taught that in school too, that is your first line of response. But I want to talk for a minute about why that's rarely, if ever, a helpful avenue. So you as a therapist are not a neutral party, even if you feel like you are. Our job as forensic psychologists is to take a bird's eye view of all the data. So we get your records and the opposing party's treatment records and maybe your client's records from 10 years ago that you didn't know about. And so we review and compare and collate and draw conclusions from that really wide lens. Now there's pros and cons to that, right? And you're working, and rightfully so, from a closer viewpoint. So you know the client better. But that also means you are in a position of advocacy. And that's right where you should be clinically. But it's terrible for the legal process because it means your credibility is suspect. Not that you're not a good clinician, you are. It just means you're not considered neutral. You're not considered objective. The entire legal system is based on a value that offers both sides all the information, and then there's an adversarial process where any piece of information can be used to refute or interrogate conclusions. The problem with a summary then, under that context, is that your summary only offers the conclusions from a non-neutral source from a person who by definition does not have all the data. So unless someone is only seeking objective information from you, so let's say the start and end date of treatment, costs, session dates, diagnosis, unless they need those things, your summary is worth very little. And it's sometimes even worse than if I got no records at all, because it casts suspicion that if you were ordered to disclose everything, but you didn't want to, you only gave the part of the story that you wanted to tell, then I need to figure out why. And you can also trust that if all I needed was a summary of your impressions or your opinions, I would have asked you. I would have either asked you for the summary, a written summary, or I would have asked you for a consultation or a phone call or a meeting or something like that. So if you need to keep offering a summary in response to a court order for records, you can certainly feel free. And some clinicians may say yes, that's fine. But know that most of us can't and shouldn't accept that. I think it's also really important to hammer home that your hesitations to disclose records may and probably will cost your client tremendously in both time and money through delays and things like that. So I'd really recommend that you just go ahead and quickly supply the records in response to the court order. Have a conversation with your client if you need to, but make sure it's clinically appropriate conversation. So don't make legal suggestions to them. Tell them if there's something in the record that you have concern about that maybe they would need to know and talk to their lawyer about, or get a release and talk to their lawyer about it yourself. But do not get overly involved. Do not offer opinions or draw conclusions that you're not qualified to make just by your lack of experience in forensics. I've literally read notes that say things like, it's hard to believe why the court is doing X, Y, or Z, but from that bird's eye perspective, I can see why the court is doing X, Y, or Z. Or I've read notes that say, they're going in for a competency evaluation and they're definitely not competent, right? But that person doesn't know the legal standard we use or the test or the case law or anything about how we decide when somebody's competent and when they're not. So really, unless you have forensic training yourself, don't assume that you will understand all of the variables that are at play here. So take-home messages here. Respond to records requests quickly. Provide the full record if it's asked for, and communicate if you need a longer time frame so that the other professionals in the court can anticipate delays. You can also really trust that forensic psychologists have our own ethical guidelines and obligations to be judicious with your records. So know that attorneys may not be, but they have a different set of ethical obligations, on their part. And that's ultimately not under your control. It doesn't have anything to do with whether or not you respond to the court order. The best inoculation against your fears about having your notes enter into the legal system are appropriate record-keeping practices. So the best records tell a coherent story of the process and the progress of treatment without disclosing every little detail ad nauseum. So your clinical goals as an author of progress notes are obviously really different than my forensic goals, but in my experience, the best notes actually accomplish both things. I get a good, clear sense of the clinical progress, and the client's privacy is protected for the most part. So basically, don't ever write anything in a note that you wouldn't want being read in open court. And that means keep it to objective, neutral observations. Another kind of take-home message would be to know your role. Accept that you're not a neutral party, you're not a forensic expert, and you may not get accurate information even from the clients that you think you know really well. You do know them really well, I'm not disputing that, but they may also not tell you things either because they're withholding them because you're not at that point in treatment yet, or maybe they don't know how relevant that information is or would be even to you. So it doesn't mean that unfair things don't happen sometimes in court. They do, but your job is to support your client emotionally through that and not to play some role as an advocate where you're going to be overstepping and offering opinions that you weren't asked for, under the veil of advocacy. And then lastly, most of your efforts to stop the information from coming out are going to hurt your client more than help them. If you have legitimate concerns about the disclosure of your records, talk to your client if clinically appropriate, or quickly seek your own legal consultation through your malpractice insurance. So that's it. Hopefully that helps you feel more at ease about the purpose of releasing records through a legal process. Your records, treatment notes, they're rarely like a smoking gun. No one cares about your typos. No one cares that it took you a week to write your note or longer. They do care if you don't respond to a court order. So that's your starting place. Lean into your malpractice carrier for anything else that you might be worried about. You can also consult with colleagues. That's a great thing to do if you're unsure. Usually your best bet is going to be to find someone with some footing in forensics. Otherwise, you're going to maybe just have two clinical heads together fretting. And that's probably who came up with this idea that a summary is going to be a better bet than just providing the records you're ordered to provide. So that's it. Be careful out there. The forensic world is wonderful and rich and fair, I think, ultimately, but it will definitely burn you if you don't know what you're looking for. So this is Sebastian Ryland with Streamline Forensics.